of Omaha. My name is Kim Brown, and I'm with the Nebraska Paralegal Association, one of the unicorns in the room. And I have the pleasure today of introducing Deborah Gilg. She's the retired U.S. State's Attorney for Nebraska and was the first female to serve in that position. So we're very lucky to have her here. Deb is a former chairperson of the Nebraska Equal Opportunity Commission, and she's now the founder of Fearless and Forward, an organization devoted to women empowerment through education and training. She is also an adjunct faculty at ASU Sandra Day O'Connor College of Law in Phoenix, Arizona. And she serves as a neutral arbitrator for disputed securities transactions under the Financial Industry National Regulatory Association. Again, we are lucky to have her here. Let's give her a warm welcome.
Well, thank you very much. I'm glad to be here on such a hot day. Well, I guess I'm glad to be inside on such a hot day. I'd be inside on such a hot day even if I weren't here. But most importantly, I am the grandmother of 6 grandchildren. So that's my proudest accomplishment. I have 3 adult children, 6 grandchildren, and 4 dogs. And, well, not necessarily in this order of priority, but my husband of 46 years, so he's not. But since he's not here, I guess I can put him at the end, so he won't mind. Okay, I was asked to give this presentation, and I have to tell you, I kind of want a roadmap for you where we're going to go today. So, on gender diversity. There's a lot of different ways we could go on gender diversity, but I want to talk to you about gender diversity and the wage gap in gender diversity in the legal field. I also want to talk to you about something practical towards the end of my presentation, and that is on negotiation skills, particularly when you're dealing with either a prospective employer or your current employer. So before we move on, though, I want to, by a show of hands, know who the really important people are in the room. And so by a show of hands, would the paralegals please raise their hand? Okay. A round of applause for the paralegals. You are the most important people. You are the backbone of any entity, organization, firm, wherever it is that you work. But without paralegals, the lawyers would be nothing, and I mean that most sincerely. Now, I'm really going to date myself as a dinosaur, but back when I started practicing law, we didn't have any paralegals, okay? And as I grew up in the legal profession, then we had paralegals, and it was such a revelation. What we had back in my day, because I started practicing law out in a rural area in western Nebraska, is I would take whoever worked for me as a legal assistant, or we called them then secretaries, and I would train them. I would train them how to do pleadings. I would train them how to do legal research. And so I kind of had my own little paralegal training system back in the day because there was really no formal paralegal training system. And so anybody who worked for me, and I'm proud to say that the people who worked for me for a very long time, were very, very skilled at what they do, far more so than I, because I also went to law school during the day, and I think I see a couple, 2-3 lawyers here that will think that, yeah, this is me, back when we had books. Okay? And when you did your legal research, you had to go to books, and you had to shepherdize and do all of that stuff. And then, of course, the computerized research came along. That came along well after I was in law practice, and I had to adjust and learn how to do that. I was having a conversation with my husband last night, and he's going to retire, and he is an attorney CPA, And he was talking about, well, I don't know about the software that I might use and what I'm going to do and so forth. And I said, look, here's the deal. We are seniors now. But as seniors, we must adapt. And so this means that we must learn new adaptive skills. And part of those new adaptive skills is learning how to do things for ourselves that others did for us. So I think in a sense I was fortunate in the law that I came up that I had to do things. And so whatever I did as a lawyer, I would do anything in the office. And so I was totally familiar with everything that went on in the office because I was also versed in how to do those things. Not so now, but good for everybody. Okay, here is something I think we could all aspire to, and that is, in particular when we're talking about Pride Month, is welcoming. Welcoming all races and ethnicities, welcoming all religions, countries of origin, gender identities, sexual orientations, abilities and disabilities, spoken languages, ages, everybody. We should all be standing here with all of you, and we should be creating safe zones for all of everybody. Unfortunately, in 2022, that's not the case. And it saddens me, actually, because I started practicing law, and now I am going to really date myself, but I think there might be one or two lawyers in here who started before me, so I don't feel so bad. And I don't have gray hair because I color it. Okay. I started practicing law in 1977, okay? I want to let you know that in preparation for today's presentation, I did a lot of research on my own. And one of the places that I went to was McKinsey. McKinsey, as you know, is the big national consultant. McKinsey does the most comprehensive study in conjunction with the Lean In organization on women in the workplace. And so I read several annual years worth of women in the workplace. The most recent one that's come out was 2021. And one of the things that it showed is the commitment to gender diversity has increased significantly in companies overall. 2015, it was 74%. 2019, we're looking at 87%. I know those numbers are really small to look at. But here's what happens. And as we get into this, we're going to talk about this. As you move from entry level and start to go up the rung to senior level, the commitment starts to show more of a gap, okay? There is quite the gap between senior men in terms of commitment to gender diversity. As you'll see, there's 50% in 2015, 71% in 2019. You look at men managers, they made an improvement from 2015 to 2019, but there's still a ways to go, okay? The gender wage gap, and this is general, this is not specific to the legal profession or any professions, this is just a generalization from the Pew Research Center about the gender wage gap among young workers in the U.S., and predictably is widest in the Midwest. And if you look at that, the wage gap is women are making 90% of what men are making, just from a general standpoint. And we can and we have to do better with that. We, as females, we can be committed to that. But it takes more than that. We have to have leaders in the position that believe in gender diversity, believe in inclusivity, believe in the fact that the more diversity and inclusivity that you have in your organization, your corporation, your firm, or in government, the better generation of ideas. And the study has shown from the McKinsey, and also from the Pew Research Center, is the better the diversity, the better the profits. Okay? Now, that probably to me is the most compelling of all arguments that's going to get and push gender diversity further is increased profits, because all of those bottom line managers that tend to be male who are looking at that are going to think, yep, well, okay, so we need to do something about that, so we're going to push it. They may not be pushing it for the right, wholesome reasons, but at this point, I'm at a point where I can't wait. The clock's ticking on me. I'm old, so I want to see that gap closed up before I die. You make me laugh. Okay. All right. Men are more likely to be hired into manager level jobs, and they are far more likely to be promoted into them. So for every 100 men promoted to manager, only 79 women are promoted to manager. So you see the gap there. You see the gap in diversity there. And when we get to the C-suite, the Megan Belchers of the world, 19%. And again, it's when you go farther up the rung, it becomes more and more difficult for women. Now, there is also a broken rung, and we're going to talk about that here in just a minute. But if you make it over the broken rung and you make it to the level of a C-suite, you're in rarefied air, although the 19% is better than it was. But it should be much, much better. States like California have mandated, when it comes to board memberships, they have actually mandated through law that there be an equal representation, gender representation on boards. And I don't know how many other states may have followed suit with California or not. But as I was having this conversation with a colleague of mine, and not to be Debbie Downer about the whole thing, but we talked about it and we said, yeah. So we wonder if that law is in place. Is it really working? Are there really 50% appointed on boards? Don't know. Because just as Nebraska has an Equal Pay Act, right? Equal pay for equal work, and a lot of states have that. We still have the discrimination that occurs despite those laws being in place. You've got to have a commitment at the very top level of organizations to making certain that those particular laws are complied with. In addition to taking on more work, women leaders often face greater challenges. For example, one of the things I want to talk about, and one of the first little things up there, are these little microaggressions that occur. And that is, so have you been in a meeting or a conference and you're talking and you're presenting your idea, your suggestion, your whatever, and you get interrupted? And you tend to get interrupted by men if you're a female. And so this, again, comes from the McKinsey and Company, and it shows how the interruption rate for men is so much less than the interruption rate for women, and it grows as women progress to management level and above. As I was saying, doing the research on this, I came across a very, very interesting piece of work that had been done. A couple of researchers, professors, law professors, had listened and compiled 15 years worth of oral arguments at the United States Supreme Court. And guess what they found? They found that male Supreme Court justices interrupted female Supreme Court justices 3 times as much as the males interrupt each other. 3 times. 1990, when only Sandra Day O'Connor when she was the first and only female on the Supreme Court, she got 35.7% interruptions directed her by other male justices. The other thing that they found from going through this is that there is a rule when you argue before the United States Supreme Court that if a justice is speaking, or if a justice is talking to you, or even if a justice is talking to another justice, the advocates are not to interrupt. That's verboten. What do you think they found in the study? They found that 10% of the time, male advocates would interrupt. And who would they interrupt? They would interrupt the female justices. And women of color, Sotomayor, got interrupted a lot more, not only because she was a female, presumably, but also because she was a double. She was a female and she was a woman of color. Okay, so 2002. So now we move to 2002. Now we've got O'Connor and RBG on the court, right? 45.3% more interruptions directed at them by other male justices. Wow. And then you would think as we got more female Supreme Court justices, the numbers would go down, right? I mean, intuitively I would think that. But no, that's not what happened. 2015, now we've got all four, three of them because Justice O'Connor was no longer on the bench. RBG, Sotomayor, Kagan, 65.9% interruptions directed at them by other male justices. So what's the solution? Is the solution to discard all politeness? Well, yes, perhaps. Because what was also discovered in listening to 15 years, I cannot, first of all, okay, let's be honest. It's 1:15 here and you've had lunch, right? And you've got to listen to me go on about all this stuff. It's really hard to stay awake, right? But could you imagine if after lunch you had to go back, put your headphones on, and listen to more oral arguments of the U.S. Supreme Court? 15 years worth. Wow. That would be a real dozer. But what these researchers discovered is that you would think that the male justices might back away, but you can see that the interruptions continued. In the case of Sandra Day O'Connor, what she eventually did was she adopted and became more like the male justices. So instead of politely saying, may I interject, or may I suggest, or would you please, all of the things that we think are cordial, collegial, right, nice things to say, well, apparently it doesn't apply in the U.S. Supreme Court. You got to just jump right in there. And so that's what she started doing in order to be able to disrupt the interruptions that were being directed at her. Kind of a sad state of affairs, really, when you think about it, that you have a female who's reached presumably one of the most powerful positions that you can reach, at least in government service, as being on the U.S. Supreme Court, and to have to put up with what we call microaggressions. Okay, I said I was going to talk about pay gaps. Now, to the paralegals. I don't have a graph here about pay gap on paralegals. I did a deep dive trying to look for something, and what I kept coming up with was, because the majority of paralegals are female, there wasn't the research that had been done to look for gender disparity in pay. My gut tells me that it's probably, if you're in a firm big enough where there are male and female paralegals, my gut tells me that there is probably gender disparity, wage disparity going on. But there aren't any accepted studies yet. So maybe one of you will have to get bold and brave when you no longer have to depend upon the paycheck coming from the men in white, or that are white. Sorry for the guys in white that are here. I have to say this to you because I always say this to my husband. I go on my rants on occasion at home about old white men, and then he's like sitting there with his with his head down, and I say, with the exception of you, Dan, I don't mean you. And I said, and I know a lot of old white men that like are really good people, like Ben Nelson, and like some of the other people in here that are good people and have not placed barriers for women in the employment world. Well, so I digress. Women law partners have a 53% pay gap. 53% pay gap. Lots and lots and lots of factors that go into that, but the fact remains is that there is a pay gap there. But it's just not in the legal field. I go off and do these talks to lots of different professions, and one of the professions I do it for are female doctors. And female doctor earnings were 28% lower than their male counterparts. That's 2017. Sorry, it isn't a little more updated. Pandemic hit, and I was too busy baking sourdough bread to update my PowerPoint. So, but that, think of it, that's an average of $100,000 less a year. What I found in the medical profession, because of all the specialties, is that in the specialties in the medical profession where women were the leaders, where women were the department chairs, such as in anesthesiology and pediatric cardiology, that there was parity in the wage when they were in charge. So in looking at the most recent statistics, the only area that I actually could pull out that showed a parity in pay between men and women, and it just surprised me. I have no answers for you on this one. I'm just going to throw it out there. Is it compliance? The compliance jobs. There was parity in pay. Now, whether that's because the corporations have got their job descriptions together, the corporations have got transparency in their pay, which is a big part of it. I don't know. I don't know the answer to that. I want to tell you a little story about Nebraska Law School. I graduated from there, but I also used to teach as an adjunct down there until I decided, sorry, I just couldn't do winters and snow and ice anymore. And so bid Nebraska Law adieu and joined the adjunct faculty in Phoenix at Sandra O'Connor. And I just happened to teach there in the winter. Can you imagine? Anyway, so I bid that adieu. And so I spend my winter months down there because I also think that the brain needs to be kept busy. And I also like the diversity of students. There's a great diversity of students in Arizona. And I learn something every time teaching. And I teach trial advocacy, so I teach young lawyers how to become litigators. And I always start out the semester by telling them, now, I've practiced law for over 40-some years. I will never, ever step in a courtroom again. Done, done, done. Finished with that. I will never kiss the you-know-what of another judge again. Done, done, done. I don't have to bow and scrape. Done, done, done. And so what do you think I did this last winter? I had 2 judges that came and stayed with me, who are friends of mine. And you think I had to revert into this amazing tour guide person of coming up with an agenda, and it was like I was briefing their vacation for them. And I was thinking of places to take. I went to the Phoenix Desert Botanical Gardens to look at the Chihuly exhibit 5 times. 5 times between January and April, they were judges that I was taking to it. And I was really good, because by the time I could say, well, last month, this particular saguaro wasn't doing this, but this succulent over here was doing that. I could give the whole tour. And my husband says, hey, I want to come down, because he's still working. I want to come down. I want to go to that Chihuly exhibit at the Botanical Garden. I looked at him. I said, no. No way. I'm not going there. He goes, but you know it so well. I said, unless you got a Your Honor in front of your name, ain't going to happen. But I have firmly decided that was really kind of a sick behavior that I needed to move past. So any judges that decide, friends that are going to come visit me this coming year in the winter, I'm putting them on notice is that, hey, I'm not doing a darn thing when you come down. So I'll point you in the right direction, and I'll give you my car and see ya. Okay, I left this slide up because I wanted you to kind of think about it. It was easier for us to go to the moon 53 years ago than to close the gender parity gap. More than 50% of law students now are female, but women are less than 25% of the equity partners at law firms. So what do we do about that? We've got to have the will, we've got to have the determination, and mostly we have to have the leadership. We have to have the leadership not only from females, but we have to have the leadership from men who are in positions of influence and power, who are not afraid to say, hey, this could be my daughter, and I want them to have the same fair shake than my son who might be in the law firm. And also, of course, we need women in those same positions. This is a little jokey from my husband, the CPA. It says, on the bright side, the gender pay gap kept you out of a higher tax bracket for another year. Yeah, well, I can't eat that, can I? So I do want to touch on workplace discrimination claims. This is overall. The 5 most common workplace discrimination claims are 53.8% claims against the employer for retaliation. Disability accounts for 33.4%, race 33%, sex 32.4%, and age 21.4%. Now keep in mind that retaliation statistic, that can encompass the disability, the race, the sex, the age. That can encompass all of those discriminations if because of some type of discrimination along the line, then there was retaliation. The hardest thing, I think, and this goes back to passing laws mandating that there be 50% men and women on boards and so forth and so on, or equal pay acts. The hardest part is the enforcement. The hardest part is having the right people with vision and the desire to do the right thing in place. I actually, as was mentioned, back in the dark ages, was on the Equal Opportunity Commission, and they have a really great web page. I looked at it before coming here, and I can tell you that, oh golly, it was a whole lot better than the web page we used to have. But if you haven't looked at it, or you might think about taking a look at it, it's actually pretty good, and it tracks you through how to file a complaint, what happens, what the steps are, and so forth. At one time after I left the Equal Opportunity Commission, I then became an administrative hearing officer for the Equal Opportunity Commission, and so I heard claims when it got to the public hearing stage amongst individuals, and that was also very interesting. But I think they do good work, and the investigators are very committed to their positions there. So something just to kind of keep in mind. Okay, so let's talk about negotiation. Let's talk about, and this kind of goes into gender diversity, and why is because women generally are not very good at stepping up for themselves and speaking up for themselves, particularly when it comes to pay and things like benefits. Okay, negotiation is an opportunity for, it might be better pay, maybe it's better benefits, maybe it's a better work-life balance, or maybe it's a matter of developing leadership potential. Maybe it's you want to be able to go to trainings that aren't specifically for paralegals or of a legal topic, but maybe it's more things that would give you the tools and skills to develop leadership potential. All these things can be negotiated. Okay, so this is the scary part for me, and it's when I want to show you a video, and one never knows if these things will work. Okay, this is what I call a brilliant negotiation amongst unequals, and it takes place between a little girl and Adam Sandler. Watch.
The truth is not in the cards right now. I thought you'd be excited to have an acting job.
If it's an acting job, we should get paid.
Yeah, you're gonna get paid in experience.
I want to actually get paid.
All right, what do you want?
$600 for the day, plus overtime if we go over 8 hours. I'll do my own hair and makeup, and I want you to pay for the 6-week intensive acting camp that my mom can't afford.
$50 for the day and a 2-week acting class at the YMCA nearest you.
$500 and a 4-week acting class.
$300 and a 3-week class.
Done.
I would have done it for $500.
I would have done it for the experience.
Isn't that great? Small steps are still progress, okay? So if you are going to enter into a negotiation, and this applies to whether or not it's your employment or any negotiation that you might do, but particularly in the employment standpoint, know your worth, okay? 80% is doing your job well, and 20% is making sure others know. You know what? Guys do a whole lot better at that than women do. Guys are much better at making sure that others know their worth, or that they were responsible for whatever project or task or whatever occurred. So you have to toot your own horn. You got to find that balance between tooting your own horn and becoming obnoxious, okay? You don't want to be that obnoxious person in the world who says, well, you know, I did this and I did that and I did this and I did that. Okay. Preparation, research pay data. Database evidence is important. Okay, so if you can research pay data, discover what a paralegal with the number of years of experience that you may have in your particular field. You may be in a hot field, maybe you're in IT or cybersecurity or one of those hot fields. Your worth is going to be more, particularly if you've got experience in it. So the other thing that's impressive to bosses, I think, or supervisors, is if you actually develop a 1-year and a 5-year career plan and share it with your boss. It shows that you're committed to the firm, you're committed to the organization, and that you want to be there and you want to contribute. So, and then also know what is going to be negotiable here. Is it salary or is it going to be non-salary items? So prepare and plan. You got to assess your situation. Do the benefits outweigh the costs in doing the negotiation? What's in it for you? But what's in it for them? And that all kind of moves into my next slide, and that's what's your BATNA, and that's your best alternative to a negotiated settlement. Now, all that boils down to is what's your bottom line, and what's the other side's bottom line. And the power that you have is you have the ability to walk away if you can't reach an agreement. And walking away may be, okay, you just, you go back to your job as it was, or maybe it's just like, sayonara, I'm leaving because firm XYZ down the street or halfway across the city is looking for somebody like me, and I'm going to go to work there. But you've got to think strategy, and you have to think about your employer. What's in it for them? What do they want? Well, they want somebody like me that has my experience, that has my credentials, that has produced X, Y, and Z for them in a very consistent manner over a number of years. And that's worth a lot of money. So negotiation's a roadmap. And yeah, you can digress off of it, but you got to start out by figuring out, what is it that you want? What is it that you want out of your job? What is it that you want out of what you're doing? And this is, again, this is applicable to lawyers as well as the paralegals, and particularly the lawyers that are female, that may be in that area with the broken rung. And by the broken rung, I talk about you only get so far on the ladder of success, and the rung breaks. And that's where a much smaller percentage of women advance up to the top. As I said at the earlier portion of the presentation, where you could see the percentages start to drop till when you got to the C-suite, it was 19%. Well, there's a broken rung in the middle of all of this that women tend to fall through and not follow up. So these are just some general skills and tips. Listening skills, listening. Listening is probably the hardest thing as a lawyer to learn. I got my comeuppance in listening skills when I started taking mediation courses years ago because I wanted to have that skill set. And in the very beginning, found that I was kind of at a disadvantage because lawyers are not very good at listening. Privately, if a client comes into the office, we're not very good. They walk in the office, and what's our goal? Our goal is find out what their problem is, tell them how we're going to fix it, and get them out the door, right? Okay. I mean, you can be honest. I know. I've been there. Lawyers interrupt quickly when the client comes in and starts to redirect the conversation, right? And that's not good. It really isn't good because you leave so much on the table. And this is true, of course, in negotiation, but it's just true generally, okay? Poor listeners miss opportunities. And so as I took more and more mediation classes, I learned to appreciate the listening skills more and more. Now, I've always told my husband, who's also the lawyer, that, gosh, this only works if both of us have taken the mediation stuff, so that you listen too. And he's like, what do I need to listen for? Well, because I want you to, that's why. And so then I moved on to arbitration. Listening skills are very important in arbitration as well. I did a 2-week arbitration this past fall that was done on Zoom, if you can imagine, 8 hours a day for 2 weeks. And I learned all about municipal bonds. So if anybody in this room would like to know about municipal bonds, I am your woman. Because I learned more than I ever wanted to know, and I started talking, I think I was talking in my sleep about muni bonds, but markups and markdowns and this and that and this and that, and listening to both sides. And after, 2 weeks of that, and trying to keep track of the testimonies, and now and then ask a question, but not very often. So it's hard. It's just hard to sit, and it's hard to listen. But I will tell you that in negotiations, it's hard as well. But if you do sit and listen, if you do sit and listen to what the other side is saying, and if you don't lose control, as long as they're not saying things that piss you off, and of course, that's going to happen. I mean, you get into tense negotiations, particularly if they're over something that's personal to you, like your pay or your benefits or whatever. You can have some low simmering aggression about things that start to bubble up. You got to keep it there. You can't let it out. You got to have patience and respect. You always have to be respectful, unless you're a male United States Supreme Court. But we already talked about that. Okay, so all right. Now I want to show you and kind of end everything here. If you're not completely asleep, the thing is, you all look pretty engaged. I have to tell you, when I teach the law students, I have a 3-hour night class that I teach the law students, and what I'm used to is they come in, they have their ball caps pulled clear down like this. They sit at the desk with their laptop, and they're like that, like they're really paying attention. And the only clue that I usually have is that they're asleep is either if they kind of go like this, or all of a sudden their hand goes up like that, or I call on them. But I'm not calling on anybody here. So this is from 30 Rock, and I had to really think about whether I wanted to show this to you today because it features Alec Baldwin, and Alec, if any of you watched 30 Rock, Alec Baldwin was the obnoxious NBC executive, Jack, and then this is a negotiation that he does with his Trinidadian nanny. And so this is called learning from your mistakes.
You had to wait for this, Sherry? I hope there was enough shark meat in the refrigerator for one of your sandwiches. Hold on. This is the same amount I was paying you when you worked full-time, and now you're just working nights.
It's the hourly rate.
You understand my confusion. I'm actually paying you more money to be here half the time. I'm not saying that what you do isn't important. Avery and I appreciate you, and Liddy just adores you. But let's just say you're at the market buying potatoes, and that 10-pound bag of potatoes costs $400. But then the grocery concierge tells you that a 5-pound bag of potatoes costs $400. Well, that would be shocking, right? Because a 5-pound bag should only cost $200. What I'm saying is that we value what you do, but this rate is unreasonable.
So, what do you want to do?
I want to resolve this fairly and amicably. And I don't want any bad blood. So, it was nice negotiating with you, and here is all of your money.
Mrs. Lost? Bliss. Mrs. Bliss.
I am supposed to represent NBC in a negotiation that Rex Belcher of the American Journal of Meetings rated 4 chairs. 4.
I'm sorry, is that another magazine about meetings?
Meanwhile, I just got worked over by my Trinidadian night nurse. I made every mistake you can in a negotiation. I spoke first, I smiled, I negotiated with myself. If I had done that during a mock negotiation in business school, Professor Widmer would have spanked me in front of the whole class. Bare bottom.
Okay, but it's harder with someone like a nanny, right? There's an emotional component. She takes care of your baby.
I mean, you just had a structural, analytic insight. Professor Widmer would have given you a good job spanking.
What is business school?
The reason Sherry can manipulate me is because she has leverage. 8 pounds of screaming, toothless, soft-skulled leverage. Liddy loves Sherry. And Sherry assumes that I love Liddy.
But you do, right?
Yeah. But Sherry can't prove that I love Liddy. So I renegotiate under new conditions. Specifically, that I hate my newborn daughter.
Wow. Jack, I could never pretend to hate my beautiful baby daughter, Emily Dickinson the cat.
Oh, boy. Sherry. Excellent. I've been thinking about our conversation earlier. It occurs to me that you are laboring under a fatal misapprehension. You think you have leverage over me, but you don't. I don't care about the baby. I've only known her for a few weeks, and other than fondness for Avery's breasts, Liddy and I have nothing in common. She is one of 2 people ever to have thrown up on me, and I haven't spoken to Joe Namath since that morning. What's more, I don't think Liddy looks like me, so evolutionarily that makes me want to eat her. In other words, either you take a pay cut or go and look for another job. Who has the leverage now, Sherry? Your move. Please stay. I'll send everyone in your family to college. Every day we give you $100 for cab fare home. Do you realize what you're doing to me, Sherry? You're unraveling the very fabric of who I am. I negotiate for a living, and I never lose. And now I have to go negotiate with my colleagues at Cabletown after having been reamed by a woman wearing Winnie the Pooh hospital pants. I don't have what you have, Sherry. A brand new baby that they've poured time and money and love into. Some helpless, pathetic, useless thing that would die if left alone. Oh God, I do have that. I have NBC.
Look, broadcast networks receiving licensing fees is unprecedented, Jack. But we're willing to offer NBC 10% of what we pay cable. I mean, okay, not to negotiate against myself, but I get where you guys are coming from.
Look, NBC is part of the Cabletown family now. It's our baby, and we want it to thrive. But your offer it's unreasonable.
So, what you want to do?
Okay. So, bringing to a close, the path we've kind of gone today is to talk about why gender diversity is good in an organization, what it brings to an organization, and then we've kind of done what I refer to as the Debbie Downer segment, which is, this is where we are in 2022. We've got some progress that's been made, but not enough. And I've tried to impart to you also a few thoughts about negotiation skills, because we as women aren't very good at asking for things for ourselves. And there's studies all over the place about that, is that we never ask for what we're worth. We're reticent to ask for things. I guess we're afraid of being told no. But we also have to know our worth, and we have to know our own power in an organization. So that's what I hope you come away with today, are a few thoughts about all of this. And I just put this slide in because I thought she was adorable. And she kind of looks like my granddaughter. So you are your own best advocate. Remember that. You have to believe in yourself. You have to believe in, again, your self-worth. And you have to believe in maintaining your integrity. So thanks for your attention for the sleepy time after lunch. I appreciate very much having been here, and hope to see you down the road. I was just saying before I came up here, the last time I talked to the paralegals was at a meeting at Anthony's in the back room, and I talked about, because I used to years ago used to teach a wills and trust class, and I would always teach famous wills. So I came and talked about the wills of John Lennon and Elvis Presley and so forth, and it was a lot of fun. So thanks for having me back. Thanks, Omaha Bar Association and Dave, for inviting me. Have a good afternoon, everybody.
Okay, so I have the distinct privilege of introducing Kathleen Neary. Kathleen came to mind because I've worked with an attorney at her home opposite Kathleen for many years, and she's a very good attorney, and she's also always very cordial and very nice to work with, so I really enjoyed working with her over the years. She's a trial lawyer who's practiced with Powers Law for 24 years and represents persons in personal injury, wrongful death, civil rights, and employment and housing discrimination matters. Kathleen is a former president of the Nebraska Association of Trial Attorneys and the Nebraska Employment Lawyers Association. Let's give Kathleen a warm welcome.
Well, hello. How is everyone? Boy, middle of the afternoon. So we decided, who's we? Me. I decided that we're going to have some fun this afternoon, okay? And that I'm here and I'm kind of a, bearer of a lot of bad news, but there is hope, right? There's always hope. Mostly hope. Anyway, well, I think this is a fantastic presentation that you put this together, the Omaha Bar Association, along with the Nebraska Paralegals Association. The topic could not be more timely. We all know that women are still making 73 cents on the dollar what every man makes. And it's a little hard, thank you, it's a little hard today to mesh my seminar topic of We Can Do It with the legal update that I'm going to present to you. The two are not coinciding very well, but there is hope, right? Now, there is not a lot of good news from the 8th Circuit Court of Appeals. In fact, the news is bad. But I really think that if we, from the plaintiff's bar, and I'm biased, by the way, I am biased, and I'm not going to hide it, and I want you to argue with me. I want you to tell me your opinions. I want to hear all the perspectives. I am here to listen and argue, okay? And you might hear a little dribble of politics. And why do we know about politics and how that corresponds with the law? Well, everyone knows that justice starts at the ballot box, right? Because the ballot box is where people go to vote. And then when people vote, we elect governors or we elect U.S. senators, we elect presidents. And what do those people do? The presidents and the governors, they appoint judges, right? And what do judges do? Sometimes they dole out justice. And sometimes they don't. I think my takeaway from today's talk is going to be, in Nebraska, my findings, my experience as a trial lawyer has been that justice depends on what judge is assigned your case. Wow. That's pretty scary, right? And what we know is but if you can get past the summary judgment, and everyone knows what summary judgment is here, right? Summary judgment. It's that legal fiction that exists in our court system. And you're like, Kathleen, summary judgment has been around for decades and decades. And the Supreme Court has affirmed summary judgment. And summary judgment, for those folks that are not employment law geeks like me, summary judgment is a pretrial motion. And it's a motion that parties, plaintiffs or defendants, can file in advance of trial and try to get the case dismissed. And in order to prove summary judgment or defeat summary judgment, you have to show, one, that there are no genuine issues of disputed material fact in existence, and two, that the movement is entitled to judgment as a matter of law. Now, I, as a plaintiff's lawyer, have filed for summary judgment on cases on liability. I think I'm one of the few plaintiff's lawyers years ago, before the courts got really conservative. Judge Peaster, Magistrate Judge Peaster, who came from legal aid and then sat on the federal bench for years and actually believed in the Seventh Amendment right to trial by jury, granted my motion for summary judgment on liability and set it on for a hearing trial on damages. But back to that evil summary judgment. And the other thing you need to know about me, my daughter's here today, Maeve. She goes to UNO, and she just finished up her 10-year student regent and student body president at UNO. So stay awake, kid. I might have a question for you. Because change starts with you. Change starts with young people and old people, people of color, men, women, LGBT. Starts with everyone. How do you, as a paralegal or as a lawyer, dole out justice? When you sit on those juries, you listen to the evidence. When you sit on those juries, you find for the plaintiff, right? All right, and I'm biased, and I know we've got everyone here, defense lawyers, plaintiffs lawyers, paralegals that work for defense firms. I think we're a little light on the plaintiffs' firms here today. But anyway, long story short, let's go back to that Rule 56 motion summary judgment. It's unconstitutional. And why do I think it's unconstitutional? Well, I'm not the only one that thinks it's unconstitutional. Has anyone heard of a federal judge who retired, Mark Bennett from the Northern District of Iowa? Famous judge. He wrote a law review article that Rule 56, the summary judgment rule, is unconstitutional. When we talk about today, we hear a lot about constitutional rights, Second Amendment, the Fifth Amendment, this, a lot about the Second Amendment. But what I can tell you is the Seventh Amendment right to trial by jury, the actual amendment says, in all cases of controversy over $20, parties shall be entitled to a trial by jury. Why aren't we talking more about the Seventh Amendment right to trial by jury? Because right now we've had this Rule 56 of the federal rules that says you can file a motion for summary judgment and you can get it dismissed. How is it that a rule by the United States Supreme Court that was not vetoed by Congress can override a clear constitutional protection? Okay. The other thing you'll find out about me quickly is I speak kind of in half sentences and I go from thought to thought. So I want you to interrupt and I want you to say, the woman here with the black sweater. If you find that something I'm saying today is wacky or crazy, I want you to raise your hand. I want you to stand up and say, Neri, you're crazy. You're wacky. I don't agree with you. The Supreme Court has the right to override a constitutional protection. Everyone, just feel free. It's the middle of the afternoon. Let's stand up. Let's get moving. Let's talk. Let's debate. So we're going to, today, aside from me trying to overturn Rule 56 of the federal rules, which I don't think is going to happen today, as trial lawyers, and it's not about the trial lawyers, it's about the plaintiffs. It's about the people who've been discriminated against. It's about the persons who bring lawsuits. And the case goes in with a lot of facts. Abby Mullen, she's not here, but she signed up. Anyway, she's a fantastic lawyer, and she has beat my ass on several cases. And but the case goes into the court, to the trial court, reading X, Y, and Z, or A, B, and C. The facts are A, B, and C when the case goes into the trial court. When it comes out of the trial court, it's X, Y, and Z. And I'm like, where are all those facts? This isn't my case. I don't even recognize this case. What is going on? But the dispensation of justice depends on who your judge is. Okay, so before I go much farther, I want to recognize two people actually 4 people, more than that, 2 people. In our audience today, we are so honored to have 2 of the fiercest advocates of civil rights and justice in our audience today. And that's Senator Ben Nelson. Thank you, Senator, for all you did. And Senator Danielle Conrad. And I'd also like to thank, because I'm probably going to irritate a lot of people or really say something offensive today, so I want to thank the Omaha Bar Association and the Nebraska Paralegals Association for putting together this great event. And I want to thank you, because I think I am going to offend some people and I probably won't be invited back. But thank you very much. I think it's fantastic. Well, since I don't know everyone's level of employment law knowledge, and that's what I do. The 3-person firm that I work with, Elizabeth Govertz and Vince Powers and I have practiced together for 24 years, coming up on 25 in January. And we are trial lawyers. And we practice wrongful death, personal injury, but we all have our little nuances. Beth does med-mal, I do civil rights, employment, housing discrimination. Vince does whatever he wants. Okay, and he does it well. But what I want to talk to you about today is I could stand up here and talk to you about legal updates all day. But I think what will make most sense to people that maybe don't practice in this area, we'll talk about real life cases. And we're going to talk about the law, and then we're going to talk about the application of law and whether justice was dispensed. Okay? So, Title VII of the Civil Rights Act. Maeve, what is that? And why would you do that? Stop whining, kid. Okay, Title VII of the Civil Rights Act prohibits discrimination based on your membership in a protected class. And it covers gender, race, national origin, religion, sex, of course, color. And it was amended then to add pregnancy as a protected class. It sounds like a fantastic law, right? That you cannot be discriminated against in the workplace due to your membership in a protected class. And also the Americans with Disabilities Act says you can't be discriminated against because of your disability in the workplace, and the employer should provide reasonable accommodation. Those laws are fantastic. But let's talk about the true application of it. There was a recent case that just came out in the 8th Circuit, and it's the Muldrow versus City of St. Louis case. This sounds like so many cases I've had, where the female plaintiff, and this is from the 8th Circuit where we are, was a female sergeant on the St. Louis Police Force. She was highly decorated. She had had an incredible career. She worked in this little boutique division called the Intelligence Unit, and she was interfacing with the FBI, on a daily basis. I mean, she was working the creme de la creme. She's a sergeant, right? So she is actively involved with this certain type of crime, and she's supervising people, and it's a great job. Well, and in this capacity with the intelligence division that she held, she was plainclothes, she worked a normal schedule, and she drove an unmarked police car. I mean, she was like CSI, right? It's cool. So a new captain comes in, and he changes her position. Okay. Well, he doesn't demote her. She's still a sergeant. He doesn't change her pay, but he moves her to this division that she characterized as a basic entry-level work of a police officer. She's back driving a marked cruiser. She's in police uniform. She's working in this rotating shift. And basically, she's saying it was highly administrative. I mean, she's not on the ground like she used to be working these sexy crimes. So she filed suit under Title VII. And the district court the trial court threw the case out, said that she didn't suffer an adverse employment action. Because we all know under Title VII, you have to, lots of different types of discrimination under Title VII. There's a hostile work environment, there's disparate treatment like the discrimination, there's retaliation, right? Well, the trial court found that she failed to establish an adverse employment action, meaning since she wasn't demoted, she didn't have her pay decreased, but there were substantial changes in duties, right? But the court said that that wasn't enough to create an adverse employment action, and they threw her case out. Eighth Circuit affirmed. So in short, and here I am being Eeyore, so long as the employer doesn't reduce your pay or cut your hours or change your title to a lesser position or lesser title, the employer can essentially put you in a closet and not face any liability. I mean, it's really shocking. But what was really, really shocking to me was the trial court and the Eighth Circuit found that this woman, this highly decorated sergeant's own testimony about the discrimination she suffered in that department was not sufficient to create an issue of fact. Wow. Have you ever been ignored? How many people in this room have ever been ignored by a man or mansplained? Oh, come on, you guys. Let's go. Come on. All of us have. Yeah. But for the court to say that her sworn testimony was inadequate as a matter of law to get her past summary judgment was super offensive. But we keep working, right? But let me tell you about a similar case. And this goes to the adversity, whether there is, you have to show under Title VII that you are a protected class member, let's just say gender, woman, that you suffered an adverse employment action, and that there's a connection between the protected class status and the adverse employment action. Well, let me tell you about a case that I really did handle, real live person. And it talks about that same adverse employment action. I guess what I'm saying is there is hope. There is hope. I'm not sure if I have trouble standing behind a podium. There is hope. Let me tell you about this case I handled a couple of years ago. And I'm doing this, I'm doing this to arm you with ammunition, because even though I'm talking about gender, we have wives, we have daughters, we have mothers, right? So even if you're a male, this applies to you as well, right? Because we know that Title VII, if you're treated differently because of your gender as a white male, surprise, surprise, you are entitled to be treated the same as women. So, gentlemen in the blue jacket here, did you know that? You did. Okay, good. It took me a long time to learn that. But that's one of my favorite things when I get these calls from Western Nebraska, and these guys, I have no rights, I'm a white male. I'm like, meh. But I'm more polite than that. I'll say, what's great is that you do have rights. So if you go to work every day and you're making widgets, and you're on the line with 10 women and you're the only guy on the line, you work the same job, you have the same experience, the same education, the same blah, 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 you're entitled to be paid the same as the women. And if you're not, you can bring a reverse discrimination claim. Oh, yeah, but those Mexicans get it a lot better than me. This is the kind of stuff I hear on the phone. And I'll say, sir, if you work with people of Hispanic origin who are Hispanic or who are born from or derived from Mexico or Puerto Rico or, Costa Rica, you have the same right to be treated the same as all of those individuals. And more likely than not, they slam down the phone on me. But in this case I'm going to talk about with Monson, and this is actually a case that was filed, so I'm not violating any privilege. I represented a woman, and this goes to the adverse employment action. She was a speech pathologist, and this really happened in Nebraska, folks. And this happened in North. I'm not going to say who the defendant was. Yes, I will, because you know what? It's a matter of public record. The Walt Hill Public School District. I filed the case, public. I'm not saying anything bad. My client was working for an ESU, and she was placed as a speech pathologist in Walt Hill Public Schools. And she found within days of arriving on site that the children there, who were 98% Native American, were not receiving special education. Now, the district was, and this is in the pleading, and I'm going off my pleading, so I'm not defaming anyone. And I'm really not defaming anyone because the Department of Education substantiated what my client said. So, and there were a lot of reports of it in the news. Long story short, my client shows up. The kids are not receiving the minutes of special education that they deserve, that they're required under law to receive. And if they did receive those minutes of education, they were being delivered by somebody who wasn't qualified. So, of course, you know what happened. She reported it to the district. She reported it to the ESU, her actual employer. Nobody did anything. She reported it to Nebraska Department of Education. Nebraska Department of Education found that what my client was saying was true and put the school district on a remedial plan. That's all public. Months, weeks after the Department of Ed finding came out, they transferred my client, Carrie Monson, who in my mind is a hero, and she had been working with students every single day in the classroom. Little kid, speech pathology, delivering one-on-one services. As soon as that Department of Ed report came out, a few months later, they transferred Carrie Monson into a basement office in Sioux City. And she never delivered in-person services to kids again. Yeah, I know. When I hear people and they call me and they tell me about what's going on with their case, I'm like, yeah, sure. I mean, like Vince always says, the case is always the best on the day that you sign it up. No. This case just kept giving and getting better and getting better. So Carrie was thrown into this basement office. She couldn't put up pictures of her family. It was a basement with no windows. There were no other teachers around. She couldn't interact with students. And she was told to design a handbook to deliver services over the internet. But ESU, who was her employer, the Educational Service Unit, they didn't have any clients. They didn't have any need for the delivery of these like Zoom-based services. So long story short, she went to work every day in that basement office. And we filed suit. And even though I told you the bad news about Sergeant Mulderon from St. Louis, there is a line of cases in the 8th Circuit, and we'll see if they survive, to be adverse, so you can bring a case and survive a summary judgment. Sometimes, and this is from the 8th Circuit, from 2007, change in employment duties or conditions that cause material change or disadvantage can constitute an adverse employment action. And I thought, and I have another case. Okay, I'm not going to tell you about that one because it's pending now. But it's unbelievable. But it's good that you know your rights. Okay. Now, let's move on. Let's move on to the Pregnancy Discrimination Act. Again, the federal law says, it's okay. Federal law is okay, but I'll tell you what. In 2015, God, and I wish I could take credit for this, but I can't. The Nebraska legislature changed the Nebraska Pregnancy Discrimination Act to make it awesome. I mean, that's not a legal term, and I don't think that's Latin, but it's kind of unbelievable. What they do now is that the new law, the Pregnancy Discrimination Act in Nebraska, it says that an employer who has 15 or more employees for a pregnant woman must provide reasonable accommodation to her. Wow, that's cool, right? Like equipment for sitting, more frequent or longer breaks, periodic rest, assistance with manual labor, job restructuring, light duty assignments, modified work schedule, temporary transfers to less strenuous or hazardous work, time off to recover from childbirth, and break time and appropriate facilities for breastfeeding. That's unbelievable, right? So I'm holding my breath that the Nebraska Supreme Court doesn't start chipping away at that really good law. This is, again, just an overview of some of the interesting laws. Now, Senator Conrad, did you have anything to do with that? Okay, why don't you tell us what you had? Hold on. Let's see. I just want to know how you got it through that super red Nebraska legislature. What did you do? Did you spike their coffee? Let's see if we can get that.
I can't take all the credit, of course. It's a team effort. Our friend Senator Keith Mello, at the time, had just had his first baby girl. And a constituent had written into him about pregnancy discrimination on the job. And he said, wow, we have to do something about this. So he brought together civil rights leaders, business leaders, legal experts to say, how can we update and modernize our Pregnant Workers Fairness Act in Nebraska to make it work for more people so that nobody has to choose between their job and a healthy pregnancy. And he did the hard work. He put together the team. We got all of the information and resources from our sister states and then, of course, from the NEOC as well. And having the business support really made a key difference in the political landscape of the legislature. That measure passed, I think, 48-0, with no votes in the Nebraska legislature, very conservative, and was signed into law by Governor Ricketts. And it was really, I think, a pivotal moment in updating our employment statutes in Nebraska to better reflect gender diversity and equity, and now has been really a push and a blueprint to get the feds to update theirs, because now over 25 states have updated their pregnancy discrimination laws, but Congress still needs to act to get that uniformity. So it was a lot of hard work, but it was also the personal connection, and it was bringing together diverse people from across the political spectrum.
Thank you. Wait, give me, what time is it? Oh, okay. So let's talk about, and we all know that women make 70-some cents on the dollar for every dollar that a man makes. So let's talk, and I'm giving just the little nuggets, okay, kind of stuff that comes out of my brain. We know that the Equal Pay Act, that's the federal law, covers employers that have 15 or more employees, right? And it has a statute of limitations that goes, that's a 2-year statute of limitations. So you can go back, 2 years. Or 2 years from the wrongdoing, 3 years for willful violations. Okay, then that's all good and fine. But I'll tell you, the Nebraska Equal Pay Act is a much better law. Why? It applies to employers that have 2 or more employees, and you can go back 4 years to bring, you have 4 years to bring a claim under the Nebraska Equal Pay Act. Now, we know that there are some advances that have been made, like the U.S. women's national soccer team. Who's been following them at all? Yeah, we love them. I mean, they are rock stars. So sadly enough, well, not sadly, in February of 2020, the U.S. women's national soccer team reached a proposed settlement in its class action equal pay lawsuit against that organization. It was $22 million lump sum and back pay to players, and then $2 million into a fund for players' post-career goals and charitable efforts. Each player may apply up to $50,000, and a promise of an equal pay rate between the men and women's national senior teams in all friendlies and tournaments, including the World Cup. Now, in 2016, several of the women's soccer players filed a complaint, and then in 2019, 28 additional female players joined. But just, and we all know that just months after the U.S. men's soccer team failed to qualify for the 2018 World Cup, and just before the women's team won its second consecutive tournament in 2019. So it was filed just about that time. But what did the court do? And this was even filed in California, right? And you think we're liberal, California, whatever. Long story short, the U.S. District Court in California, for the Central District of California, dismissed the substantive portion of their Equal Pay Act claim. Some players appealed the ruling, but there was this proposed settlement after the appeal was filed. But even though the court didn't dispense justice or serve justice in this case, I don't know what it was that made them enter into this agreement. Was it public opinion? Was it bad press? What was it? But all I know is that they're waiting for court approval on that $22 million settlement. So it's about enacting the laws, Senator Nelson, Senator Conrad. It's about being advocates for your daughters, yourself, your aunts, your nieces, whomever it may be. Because discrimination is far and wide. Let me tell you about another loss I have. And by the way, I do win cases once in a while. I'm just telling you about the bad ones, okay? Because those are the ones that keep me up at night. The ones that I lose, the ones where I feel like there wasn't justice dispensed. I represented a woman. Her name was Barb Perry. It is Barb Perry. She's a lovely, smart woman. She has 2 master's degrees. She worked for Zoetis. And Zoetis, and this again is public knowledge. It went up to, on appeal to the 8th Circuit. So I'm not divulging anything confidential here. Zoetis designated, she worked as a lab tech, and the Zoetis designated their lab techs by grade, such as like 10-1 or 20-2 or 30-1, right? And the higher you went up into the 20 and 30 grade range, the more money you made. Well, Barb had been a long-time employee, exemplary employment evaluations. So she's working hard. Her boss, a guy by the name of Rex Newsom, manager, saw how wonderful she was. And even though she was qualified or classified as a 20-2 lab tech and making 17-something an hour, he gave her all the duties of the 30-1, 30-2. So she was performing all these duties that she wasn't getting paid for. And what do you say to your boss? What do you say to your mom? If I say, clean your room, kid, you're going to say, absolutely, mom, right? But if your boss tells you to do something, you're not going to say, I'm not doing it because I'm not getting paid for it, right? People have bills to pay. So in this case, Barb for years had been doing the duties of the 30-1 and 2 and 3 positions and not getting paid for it. All right. So along comes a guy named Nathan Gross, and they hire him, and he has 2 master's degrees, but they hire him off the street, and they pay him, they classify him as a 30-1, and they pay him $21 an hour. Now, how do you think Barb found out about that? Okay, well, when Nathan Gross was fired because he couldn't do any of the duties, starting with 10-1 or the 20-, he couldn't do even the entry-level work. But he was making $21 an hour while my client was making 17 and change. So When Nathan Gross was finally fired for incompetence, he left his offer letter in his desk. So when all the female lab techs found it, hey, they're like, what about us? Hey, hello? Barb went into the human resource office and said, look, we found this letter where he's making $21 an hour. He can't even do the basic entry-level stuff. I want a pay increase. And the human resource person looked at her, looked up Gross's pay stuff on the computer and said, he's not making that much more than you. And that was the HR's response. Long story short, Barb had it up to here. They wouldn't get her a pay raise. She was doing all these additional duties. She was being evaluated on them. She was doing them at the request of Rex Newsom. When I deposed Rex Newsom, and a really good defense lawyer in Omaha was defending the case, he's really, really competitive, and we're competitive with each other. So I deposed the manager, Rex Newsom, and I said, you expect in kind of cases that you're always going to get the stuff from management. She's lousy. She came to work drunk. She was high. She was sleeping with everyone. God, she was running a prostitution ring on the side. Right? That's what you expect. But Rex Newsom, who was the manager, it blew me away, and I'm not usually a loss of words. And I said, Mr. Newsom, you've read the complaint. Yes, sir. Yes, ma'am. You don't need to call me ma'am. Sir, we've alleged, sir, that Barb Perry was far more skilled and educated than Nathan Gross. Do you agree or disagree with that? I agree. What? Whoa! Okay, this is going to be fun because my opposing counsel is about ready to die. So I said, well, sir, Barb Perry says that for all these years, she's been earning the classification salary of a 20-1 employee. That's true. Was she performing the duties of all the 20-1, 2, 3, 4, 5, 6 and the 30-1, 2, 3, 4, 5, 6? Yes, that's true. Did she do it well? Yes, she did it well. But she's paid less than Nathan Gross. That's true. So after I had a minor heart attack, I said, so we closed up the deposition, and I look at my opposing counsel. I wish he was here today, but he's not, because he was so bitter. And I said, Ken, guess who's filing for summary judgment? And he's like, well, we still win on the retaliation, Neary, so don't get a big head. And so anyway, long story short, we went, again, it's about the dispensation of justice. If I would have had Judge Gerard, Judge Battalion on that case, I filed for summary judgment. The liability was so clear. I filed, so there were dueling motions for summary judgment on this case. And it was assigned to a judge that knowingly does not like employment cases. And I like the judge very much. But he granted the defendant's motion to dismiss, the motion for summary judgment, and found basically against decades from there, all decades of Eighth Circuit case law that says you do not look at job titles in determining whether there's a violation of the Equal Pay Act. You don't do it. You have to look at the work that's being performed, right? You have to. And there are this whole line of Eighth Circuit cases that say this. I couldn't believe it. And this judge, who again I like very much, I just maybe would have to do something terrible to him so that he would never get assigned any of my cases. I think about that sometimes, like, okay, would I lose my bar license if I did something offensive to a judge so that they would have to like recuse themselves from my cases? But anyway, I won't. But he found that the job titles ruled the day. And he relied on cases from the District Court of New Jersey, the District Court of Michigan, the District Court of Mississippi. And I'm like, what the hell planet are we on? Oh my God, the one time in my career where I have all the cases that back my client's claim. So I thought, okay, so Vince and I have a discussion. I say, I'm appealing this. This is decades of Eighth Circuit precedent that was ignored. We're appealing it to the Eighth Circuit. So we appeal it to the Eighth Circuit. And I thought, by arguing to the Eighth Circuit, listen, in this case, Judge on the Eighth Circuit, this was your opinion. You wrote this opinion that you don't go on job. This was during the oral argument with the Eighth Circuit. And long story short, the Eighth Circuit affirmed the district court. And the Eighth Circuit said that she volunteered to do these duties, that it was a benevolent act, that she, because she volunteered to do these duties, it was not a violation of the Equal Pay Act. Yeah, it stings. So anyway, what time is that? I'm sorry. Okay. I don't want to, I could go on, but let's talk about a little good news. We all know that in 2019, the United States Supreme Court extended Title VII protections in the Bostock v. Clayton County case to members of the LGBTQ community. Okay. But then more bad news. Okay. That's all good, right? People just need to be able to work and not be discriminated against, right? Go to work, do your job, get paid, take care of your family, pay your bills, right? So anyway, the U.S. Supreme Court extended those protections to LGBTQ plus community under Title VII. But in today's paper, it's kind of unbelievable to me. I don't know if I brought the newspaper. So there's an article in the Lincoln paper today, that 10 years ago, the Lincoln City Council passed the Fairness Ordinance, which would have extended those protections. Omaha's had it for decades, or over a decade. There's a decade? Yeah. And, you haven't. So about 10 years ago, Lincoln City Council passed it. Then there are opponents that gathered the petition signatures to put it on the ballot. The City Council of Lincoln never put it on the ballot. So this year, the Lincoln City Council, with 3 gay members on our city council, passed the Fairness Ordinance that was amended a little bit. And it was, of course, after Bostock, so we know that it's codifying the U.S. Supreme Court approval. Well, there were opponents within the community, within the LGBTQ community, that said that they feared retaliation and violence if, this went to a vote of the people. Because, the city council passed the ordinance. The opponents again this year gathered enough signatures to put it on the ballot, right? Which all the polls show it passed 65-35 in Lincoln. But the city council, with 3 gay members of the council, reversed themselves and rescinded the Fairness Ordinance. It's unbelievable to me because they feared some retribution, some retaliation, that they didn't have enough money to fight this ballot issue. So it's like 1 step forward, 2 steps back. Anyway. Okay, let's talk about another fun thing. And I want to talk about things that may affect you, your daughters, your wives. How many people read about the Elizabeth Mays versus Shakers case in Nebraska? And I'll give you a hint. It was my case. Okay. But does anybody ever remember reading about an exotic dancer who sued Shakers because she was classified as a contract worker instead of an employee? And so I represented Ms. Mays, and we sued because we said that she was due and owing an hourly rate and overtime because the employer controlled the terms and conditions of her employment. And in that case, the trial judge ruled with us on every issue. And we were able to prove that, and again, these are under the wage laws, but this affects everyone, right? Because I'm seeing more and more. I have a case right now where the young woman was working for a CPA firm, and they classified her as an executive assistant, right? So that they could pay her a salary and wouldn't have to pay her overtime, right? And I said, well, why don't you think you're an executive assistant? Because if you're an executive assistant under the FLSA, the Fair Labor Standards Act, you don't get overtime. You're an exempt employee for overtime laws. And she said, Kathleen, I copied things. I made copies of returns. Kathleen, I only sent out emails to groups that somebody else had written. You know, that's what I did. I was not an executive assistant because executive assistants have to be able typically to make hire and fire decisions, you know, have real supervisory authority. But the CPA firm, in my opinion, did this so that they didn't have to pay her that overtime for all those hours she works during tax season from January to April 15th. They work a ton of hours. So that case is probably going to be litigated. But in the Mays case, which again is like an FLSA case, we were able to prove that the employer, the Shakers, it was a juice bar, that they controlled 50 terms of her employment. They made her clean the toilets. They told her what lotion she had to use, that when she was doing her dance, they picked the music. They told her when she had to be naked or down to her panties by the third song of her set. They had 50 house rules. So we were able, so we won at the trial level. When it went up on appeal, the Supreme Court, Nebraska Supreme Court said you didn't prove interstate commerce. So we're going to take away the FLSA verdict or judgment, but we're going to let you win on the wage claim. So she's entitled to an hourly rate. So the Nebraska Supreme Court found that she was employed. So what I'm telling you is, just because somebody wants to classify you as an executive assistant or somebody non-exempt or your kid or your whoever, niece, or your nephew, your son, I mean, there is no gender issue on the FLSA. Everyone is entitled to be paid fair wages and not be misclassified. So, okay, you know what? I'm putting these down. All right, so I could go on and on, but I hope that this has given you a flavor for Nebraska and federal employment law. And I want to just see if anyone has any questions, or you're too afraid to talk to a crazy woman. But I want to answer any questions, and you can always find me, our website, Powers Law Kathleen. Call me. And as long as you're not from Western Nebraska, a white guy calling saying, I don't have any rights, I'll talk to you, okay? I'd be happy to talk to you. But I think what it means is justice is dispensed when people vote. And justice is dispensed when we have persons as elected officials who are committed to civil rights. And that justice is dispensed when we have our elected officials appoint and confirm judges who think civil rights and anti-discrimination and anti-retaliation are important. That this world isn't always about just white males. You count, though. You count, right? And you have the rights. You have the rights that women have. So when you fight for your rights, you're fighting for the rights of women. And with that, I would open it to questions if anyone has any. Yeah, Caroline. A challenge. Oh, I love this. And if I need some backup, anyone jump in.
Okay, so here's my challenge. Based on what you said, I'm getting the impression, and you correct me if I'm wrong, I don't want us to think that the enemy is the white man.
I agree.
I don't think that's it.
I agree.
But I heard a couple of times you teed it up that way, and I think that that's a little biased and it's probably a little unfair.
You're
and
right.
I say that because I've been black all my life. Okay, so one of the things I've noticed is it's not necessarily a white male thing. It's a human. It's the dregs of human society. We have become less polite. We have become, even though we're more educated when it comes to diversity and inclusion, but I think we have become so antisocial, even though we've got all this social networking, the love is just not there. The respect is just not there. Or you really have to just try to generate it to keep it going and keep that momentum going. I do think that there is a force that's trying to pit whites against blacks, straights versus gays. I do male versus female. I feel it, and I know it's there. So we have to be very careful not to make a certain people group an enemy. And I say that because in my lifetime of my 29 years, in my lifetime, I have seen discrimination, I've seen exclusivity between blacks, between women. I've seen it between men. The competitiveness. I've seen some of the nastiest situations I've had were with women. So we have to be very careful. So, and I would say this, and I appreciate your candor. I love it. You're just real, and I really love that about you. I just think it's very important that we take every bit of adversity, because I can ask you to raise your hand in the room if you've never faced adversity. And I bet you not one hand would go up. We've all faced a level of adversity one way or the other. But instead of looking at a way of saying, okay, who's at fault at this? What's wrong with us? What's wrong with society? I look at it as, okay, this sucks. I don't like it. But then what can I do? How can I raise my level of character, patience, long-suffering, love, tenacity, right? Just to barrel through it. So even though it may be a black and white thing, it may be a white male that has told me, and that's happened to me. Well, we gotta eliminate your job, only because I don't like you. That's happened. But I don't blame him. What I do think about that is it was just time for me to go. And each time I've gotten better and better and better. So anyway, I'm not your enemy. White men, love you all. You're not my enemy. You know what I mean? So anyway, keep doing what you're doing. I love your women.
You're a million. Okay, so I want to amend my answer, and I'm not going to back down from this. Okay. For the gentleman in the room, as long as you're not right-wing extremists, I apologize. I still stand by my dislike of white extremists. The extremists, the super right-wingers. It's just like a level that I've never seen before in all of my days. But it is what it is. So my apologies, gentlemen. Okay, I saw somebody. Oh, yes, yeah. Oh, God, we will acknowledge you.
This is on behalf of incompetent white men.
Yeah, so we need here. We need the mic.
In your cases, how do you distinguish between incompetence and malfeasance? Do you have to prove that? Does it matter? Is it discriminatory effect?
Yeah, that's a good question. You mean like the Nathan Gross who was incompetent, couldn't do his job in that Barb Perry case? Yeah, he had some other issues going around. I mean, he had some addiction issues. I think that is part of the record, and I don't take joy in that, right? So, so do in my cases when okay, Kutai, Marsha Washkun had a lot of cases against Marsha, not for a while, and anyway, you know, one of the go-tos, and I'm not saying Marsha did this, but one of the go-tos for defense lawyers is to, you know, attack the plaintiff as being incompetent, an idiot, this, a lawbreaker, dope smoker, you know, selling weed through the, you know, whatever you want. So yeah, we have to beat all that back in my cases.
I mean, as a defense of, we're not being discriminatory. We just run our business here.
Oh yeah. Okay, yeah. And the Eighth Circuit's got you covered all over the place. So, and the Eighth Circuit says that if it's oh God, I got to tell this one little, and this is going to be the answer. I represented this guy named Ron Ryan. He had an IQ of 56. He worked for a place called Capital Contractors. He couldn't read and write. And he was one of my all-time favorite. And again, this is a published opinion that we lost. Again, we do win sometimes. But Ron, his boss would, and this is getting to an answer to your question. His boss, this guy named Colin, Troy Colin, I think. Anyway, he was a big old guy, like 6'6", the supervisor was. But he would say to my little guy, Ron, and I loved him, and he would say things to Ron like, "You're a complete idiot. Did your mother drop you on your head? You're a fucking idiot." He would say, this is all on the record too. And he would just curse at Ron, curse at him. And you know it was towards his disability, right? Because he couldn't, 56 IQ. And so we filed suit, hostile work environment under the Americans with Disabilities Act. And defense lawyer, very good lawyer, they said, the claim was bigger than this, but I'm just going to focus on the hostile work environment. And we needed to prove under a hostile work environment that member of a protected class, that the working conditions were sufficiently patterned and pervasive with unwelcome comments to create a hostile work environment. Law sounds good, but here's the actual application of the law. We presented all the evidence where his boss called him, "You idiot, your mom dropped you on your head, you can't read right, you're a fucking idiot, you're dumb, you're stupid." That's what his boss called him. Well, in the record, the defense lawyer was really smart and said in Ron's deposition, "Ron, did you ever call your boss any names?" And Ron said, "Well, once in a while I'd call him the Jolly Green Giant." Right? Ron told the truth. And this judge, who I've mentioned before, not by name, that I like very much, but I wish he'd never get one of my cases again, found that it wasn't a hostile work environment based on a disability, that it was workplace banter, because my client had called him the Jolly Green Giant. But in that case, they also said that Ron was, incompetent. But they didn't say that he was incompetent until after he hired a lawyer and all this stuff, right? But the Eighth Circuit is really solid. Like the judge, and in this judge, who will go unnamed, that I really like, but again, I wish he'd never touched my case. He called the conduct in the Ryan case boorish, B-O-O-R-I-S-H, that it was boorish, but it wasn't discriminatory. Unbelievable, right? But when they make a claim that the employer will say, "We had to fire so-and-so because they were incompetent, they were late to work, they were blah, blah, blah," it's considered in the courts that that's a valid reason. And then I have to come in with my client and basically disprove it and show that what they say is not true, or that they had treated members outside the protected class differently. So let's just say you've six women all work for the same place, and that you all walk into work 5 minutes late every single day. And with you is a male who does your same job, right? And he walks into work late 5 minutes every day too. But Baird Home only fires the women. They don't fire him. So in disproving a valid excuse, so if you're defending Baird Home when I sue them, you're going to say, we fired the 6 women because they were always 5 minutes late coming to work. And then I challenge it under law using comparator evidence saying, but this gentleman was with them every day and he was 5 minutes late and you didn't fire him and he holds the same position. So if you can disprove discrimination, you can disprove a proffered reason that's non-discriminatory by showing that others outside the protected class are treated better. How's that? Okay. Anything else? Okay, and I'm not suing Baird Holmes, so don't report that to anyone. And anyway, it was Allie Bayless, my good buddy, who said, Kathleen Neary, you are missing the damn boat on these Fair Labor Standards Act cases. There are misclassifications rampant. So get your head on straight, Kathleen, and start taking those cases. They're good cases. So tell Allie I finally listened after like 10 years. All right, I think that's it. Okay.
I have the pleasure to introduce our fourth speaker of the day. Angela Cooper is the founder and principal consultant of MindPower Strategic. Angela previously served as the inaugural Chief Diversity Officer and Vice President of Diversity, Equity, and Inclusion at Mutual of Omaha. She led the organization's comprehensive diversity, equity, inclusion, and culture shaping programs for over 5 years. And it is my pleasure to turn over the mic to Angela.
Okay, let me get set up here. Thank you so much for having me. I just have been so impressed with the speaker lineup today. I'm just really thrilled to be here, a part of this conversation with all of you. And my name is Angela. I use she, her pronouns, and I'm excited to get going. I'm actually going to start us off with a quick video today. So let's see if I can figure this out.
So here we go. Hi, Erin.
Hi.
Okay, so I'm going to just give you some actions to do, and do the first thing that comes to mind. Show me what it looks like to run like a girl.
For sure.
Show me what it looks like to fight like a girl. Now throw like a girl.
Aww. My name is Dakota, and I'm 10 years old.
Show me what it looks like to run like a girl. Throw like a girl. Fight like a girl. What does it mean to you when I say run like a girl?
It means run fast as you can.
So do you think you just insulted your sister?
No. I mean, yeah, insulted girls, but not my sister. Actually, don't know what it really, if it's a bad thing or a good thing. Sounds like a bad thing. Sounds like you're trying to humiliate someone.
So when they're in that vulnerable time between 10 and 12, how do you think it affects them when somebody uses like a girl as an insult?
I think it definitely drops their self-confidence and really puts them down because during that time, they're already trying to figure themselves out. And when somebody says you hit like a girl, it's like, well, what does that mean? Because they think they're a strong person. It's kind of like telling them that they're weak and they're not as good as them.
And what advice do you have to young girls who are told they run like a girl, kick like a girl, hit like a girl, swim like a girl?
Keep doing it because it's working. If somebody else says that running like a girl or kicking like a girl or shooting like a girl is something that you shouldn't be doing, that's their problem. Because if you're still scoring and you're still getting the ball on time and you're still being first, you're doing it right. It doesn't matter what they say. I mean, yes, I kick like a girl and I swim like a girl and I walk like a girl and I wake up in the morning like a girl because I am a girl. And that's not something that I should be ashamed of. So I'm going to do it anyway. That's what they should do.
If I asked you to run like a girl now, would you do it differently?
I would run like myself.
Would you like a chance to read it?
Why can't Run Like a Girl also be in the race?
All right, powerful stuff, right? So I just want us to stop and sit with that for a minute, right? Because when we think about gender, we all believe it should not be something that holds us back. And similarly, I think all of us would agree that we think people of all races and ethnicities should have the same opportunities and the same education and the same access to quality health care. And we think that people of any age.
You want that up there? Or is that part of the slide?
Yep, that's part of the slide. That's okay. She's taking good care of me today. That people of any age should be valued for their contributions, right? So if we believe all of these things deep down, if this video resonated with you and you're thinking, yes, that is what I believe, then why is it that all of these things are also true? More than half of Americans over 50 report being involuntarily pushed out of their jobs before they're financially ready for retirement. Only 15% of the highest grossing companies in America, only 74 out of 500 have women CEOs. And a huge body of scientific research shows that racial and ethnic minorities receive lower quality health care. In fact, it's true that white patients are more likely to get medical treatment for the same conditions than Black patients. So why is this happening, right? If we believe all of these things, then why is this our reality? And who is causing this situation, right? Is anyone in here consciously working towards these outcomes? No. Right? We're not. So what is happening if we're not consciously working towards these things, but they still exist? Then maybe it is time for us to start looking at what is happening unconsciously. And that's what we're going to talk a little bit about today, is unconscious bias. And we've heard that mentioned a few times. Some of the earlier speakers talked about it. We're going to dive a little bit deeper into it. And this is a concept that's really now coming to the forefront of the diversity, equity, and inclusion work, because the traditional paradigm doesn't work anymore. So when we think, we've always kind of assumed the good people are the people who are not biased, and the bad people are the biased ones. Neuroscience is pointing us to a new understanding of the human brain that shows us that there is bias that is present in ways that we are not aware. And we need to start asking ourselves, if these outcomes are true, what if people around us all day are making unconscious choices that are leading us to these outcomes and they're not aware that they're doing it? What if their choices are harming people, discriminating against people? And what if the people who are making those choices are us, right? So we're going to talk a little bit about that today. Here's what we're going to go over. We're going to take a little bit of time at the beginning just to establish some of the language around diversity, equity, and inclusion. We've heard a lot of words today, and I just want to go through the definitions to be sure we're all on the same page. Then we're going to look at the neuroscience of bias and how the human brain works. And then we're going to go through a framework for how we can mitigate the impact of bias. So you'll all leave here today feeling equipped to do something. So I'm going to start with a little bit about myself as a bit of an introduction, some of that uncurated story that Megan talked about at the beginning. I'm starting with the most embarrassing photo. So I don't know how many of you would be comfortable putting a photo of yourself in the 1980s up in front of all these people. But here is me and my family. My brother's head is kind of cut off up there. But I grew up in the middle of Nebraska. I'm the oldest of 5 kids. That's me in the front with the big red bow. I moved, my parents. These are my parents today. They are the sweetest. This is when they were doing live music on Facebook during COVID called Songs for the Situation every night. Very fortunate to have 2 loving parents who are married for 46 years. I've been married for 22 years this week. This is my husband Quinn and my 2 children, Eli and Zoe. They're a little older now. This picture was a few years ago. This is actually my daughter just a few weeks ago. She's holding a cupcake from Whole Foods. It's a vegan cupcake. And Zoe has grown up with a lot of food allergies. So when she was born, when she was actually 12 months old, we found out she was allergic to peanut, tree nut, soy, dairy, eggs, and all beans and peas. And I was just like, what am I going to feed this kid? But it's really been a learning journey for me as a mom. And when you think about inclusion for a child and all of the holidays and celebrations that are built around food that that child can't participate in, that's been something that's really been impactful for our family. This is my son today. He's 14. He is just towering over me in the last year. He's going into 9th grade this year, and he has had just a really tough time this past year. So he has a lot of gastro issues. He's been in and out of children's for several tests. He missed 40 days of school this year. So to celebrate, I took him to Austin for spring break, and this is the two of us. He's just such a resilient kid, and he's just a bright, bright light in my life. This is my husband and my daughter. They're two of a kind. Last year, about a year ago in May, I heard, I was on a Zoom call in the basement, and I heard something out back. I heard someone, it sounded like they were kind of calling my name. Peek out the window, I see my husband army crawling up to the house, dragging himself up. I ran outside. He had fallen, and he broke his femur, right here. And we had an emergency surgery. We were in Bergen for a week. They put in a plate and several rods, and he came home in a wheelchair. And I was working full time. My two children were at home, back and forth to summer camps. It was just a really, really difficult summer. It was 12 weeks of no weight bearing, so full-time caregiving, like couldn't get his own food, couldn't take a bath by himself. So we struggled through it, and about 6 weeks later, he was on crutches, worked from a wheelchair to walker to crutches. And his friend called and said, I'm going to take us to the College World Series. I got us accessible seating. You need to get out of the house. His friend comes, picks him up at the house, and he's crutching down the driveway, and he falls on his crutches, re-breaks the femur. Yes. Actually, above the first break. So they had to put a rod from his hip down to his knee. And it's been a whole ordeal this past year, kind of getting through it. And, this was him being a really good sport. I bought him that T-shirt, which he wore everywhere. But that's a little bit about him and what he has been through. So we've been trying to really kind of get into some fun back into our lives after a rough year. We love to be outside. My parents are big into fishing, and this was just a few weeks ago. We were out at Walnut Creek Lake, and I caught this little sunfish. Maybe it's a bluegill. But we had a ton of fun. We also, speaking of fish, these are fish tacos. We had a food blog during COVID. And once Quinn broke his leg, we had to let that go. We didn't have time to do that anymore, but we really love cooking in our family, and our kids get into it too. As you may have noticed, I have grown out my gray hair during COVID, and I've been embracing my silvers. I'm 45, but I got my first gray at 23, and I finally just decided, I don't know why, here I am, the diversity leader, and I'm covering up my, authentic self. So I really have embraced it, and it's been a really pretty incredible journey. There were times where I was wearing a lot of hats, and I was, it's hard when you go through society and people kind of expect you to do something different, but I've ended up really loving it. And I'm proud of it now. My friend Bridget noticed me up here. We know each other because I used to be a dance fitness teacher, and I taught a class at the YMCA for several years, a hip hop dance fitness class. This is a picture of me teaching, and I just love it so much. Unfortunately, I had to give it up about 3 years ago because I developed a disability. It's an invisible disability, and it's a nerve condition and an injury that makes it really difficult for me to type or use my arms for a lot of really intense work. So I have now, you are looking at someone who has completely transitioned over to voice dictation software. So if you ever need to know anything about Dragon or any voice dictation software, I am your girl. I have struggled through it all. But it's been quite a journey and has really given me a heart for people who are differently abled and who are weaving their way through a world who, that was not made for them to function in ideally. So that's a little bit about me. And, maybe when you look at me, you guess some of those things and maybe you don't. But I like to start off with that just to kind of get us into the mindset of thinking about diversity and that there is so much beyond a person than what you think you might know when you first look at them. So we're going to start with a few of these definitions I talked about. And when we think about diversity, it's really very simple. Diversity is nothing more than difference. It's any way that you are different from me. There is an analogy I really like to use when I talk about this, and you may have seen this in the past. When we think about an iceberg, there is so much more beneath the surface than is immediately visible when we look at someone, right? So you can see some of those things above the waterline. And a lot of times when we do diversity, equity, and inclusion work, we think about race and gender right away. And those things are very relevant as we're doing the work. But there are so many other aspects of a person's identity. And the thing is, you don't really know what is important to any one person about their identity until they tell you. Just by looking at someone and thinking you may place them into this box based on what they look like, you don't know if that's an important part of their identity to them or not. For instance, I have this invisible disability and it's really shaped me and the core of who I am and how I function in the world now, but that's not something that most people have any idea about. So, think about your own identity as you look at this list. And are there things above or below the waterline that are really important to how you define yourself? The one thing that we have to remember is that there is no one aspect of diversity that we do this work around. It's important for us to acknowledge all of these things interact with one another to really shape a person's identity. So, if we think about the pieces of my identity that are really important to me, I put some of them up on the slide here. You see I have all these circles with labels in them, and you see I have a really large circle there labeled white. As a white woman married to a black man and raising 2 children of color, I will tell you, I have had a front row seat to how they have been treated differently, how they walk through the world differently. As a diversity, equity, and inclusion officer at a Fortune 500 company, I've seen all the research that shows, race shapes a person's life experience. But now it's also really personal for me. And having seen all of that, my whiteness is something that is constantly on my mind. It's something that I am aware of in almost every situation. And so that's an important aspect of my identity. Now, I don't know that that would be top of mind for other white people. So again, when I say these things have varying importance or awareness even to an individual, that's very true. Now that also intersects with these other pieces of my identity, right? As a mother, raising children of color, as a wife, as a woman. My experience is different than other people who might have some of these same identities than me because these things overlap and this is a term that we use called intersectionality. The ways that all of these different aspects of identity intersect with one another, combine, overlap, that's what really shapes a person's experience. And we have to acknowledge that that's also what leads to certain advantages or disadvantages for a person. Sometimes people in certain identities don't have access to the same opportunities. Sometimes they don't have access to the same people or the same information, or sometimes they don't feel as if they belong in certain instances. And that's probably a good transition to talk a little bit about belonging and inclusion and how we really define that. So the words diversity and inclusion are often used together. They mean very different things. So here's a quote some of you may have seen that I really like by Verna Myers. Diversity is being invited to the party, but inclusion is being asked to dance. And when we talk about doing this work, we really need both of those things, because being present in a room is not the same as being invited to dance while you are there. Inclusion can mean very different things to different people. And I put some of the words up that we use to describe inclusion here. But it really depends on what a person feels like when they are included. And inclusion is active. It's something that we have to do intentionally, because when we fail to intentionally include other people, then we're unintentionally allowing them to remain on the sidelines or to feel excluded. Right? So we're going to talk a little bit more about how we can do that today. But before we kind of dive into the next concept, I just really want to say, I shared some research at the beginning about inequities and how they exist. And the research is really important to understand, but we don't even really need the research to really get at the core of what this is, right? We can, in fact, just do a really little simple exercise right now to help everyone understand. So I'm just going to ask you, if you are here today and you are white, stop and think about, would you consciously choose to trade places with a person of color? Would you choose to be Black in today's society with the ways that Black people have been treated differently, with those different outcomes that the research shows that they receive? And, when I've asked people this question before, the answer is almost always no. We see that these inequities are happening in our society, and we wouldn't want them for ourselves if we're white. And we shouldn't want them for anyone else, right? And this is when we talk about opening the door to the conversation around equity. This is really important for us to understand. A lot of times these words equity and equality are used interchangeably, and I'm just going to take a minute to talk about the difference between these two. So equality means, as you can see in this illustration here, that if everyone has the same goal, which here people looks like picking fruit off of a tree, equality means everyone is given the same resources to achieve that goal. So you see they all have the same size box that they're standing on. Equity recognizes people have different circumstances. They need different things to be able to achieve those same outcomes. And so when we're thinking about the outcomes that we want, we have to acknowledge it might require us to really focus in on the individual needs instead of offering everyone the exact same. Here's another illustration that I really like, right? So if we know that the goal is for people to transport themselves somewhere using a bike, we wouldn't give all of these people the exact same bike and expect them to be able to do that. Right? People have these individual needs, and so while the terms equity and equality might seem very similar, the implementation of one versus the other can lead to dramatically different outcomes, right? Okay, so there's some of the basic terms that I wanted to kind of establish for all of us as we're going to start our conversation today. And I think, the realization of difference, the realization of the inequities and some of the advantages and disadvantages that are associated with difference, and acknowledging that we must actively work to create an inclusive environment so that the outcomes are good for everyone. That's where we're going to start today. And I think understanding all of these concepts really gives you a powerful mindset that can make a significant positive difference in your own life and in the lives of others. So this is kind of the foundational level. Then what is the next level, right? So now we're going to go a level deeper. And in order to do that, I am going to show you, let's see if I can do this, another video.
You can do it.
All right, I gotta minimize this one.
Cognition Center at Yale University, otherwise known as the Baby Lab. Parents bring their children here to unlock the mystery of what they're thinking. The baby whisperer is Dr. Karen Wynn. She and her team of researchers believe knowing good from bad isn't learned. We're all actually born with those instincts. We watched babies as they were presented with a puppet show. Here, a puppet struggles to open a box. First, we see a green bunny who comes along and helps to open the box. Good behavior, good bunny. Then we see an orange bunny slam the box shut and run away. Bad behavior, bad bunny. When given a choice between the two, more than 80% of 6-month-old babies chose the good bunny. And for those just 3 months old, it goes to almost 90%. So if babies know the difference between good and bad, what else do they know? Researchers here say very young babies very clearly like people who are similar to them. Thank you. Oh, that's so nice of you. And dislike those who may be different. But we're not talking about physical differences here. We're talking about differences of opinion. Think of it like people in the same political party or rooting for the same sports team. For Berkeley and Parker, it's simpler. Do you like Cheerios or do you like graham crackers?
Which one would you like?
Berkeley chooses a graham cracker. Then she watches as a gray cat and an orange cat are presented with the same choice. The orange cat chooses the same as Berkeley.
I like graham crackers.
The gray cat chooses differently.
Ew, yuck, I don't like graham crackers.
So which cat does Berkeley gravitate towards? You guessed it, the orange one.
Okay.
One who shares her opinion.
So that's the idea, is that Berkeley gravitates to
Right.
the doll that's similar.
To the like-minded puppet. And away from the puppet that had different opinions from her.
And is that something that's learned, or is that just something innate?
Well, we found this in babies as young as 7 months of age. I think it's just a natural aspect of human nature that we're built to judge, in what ways is this individual like me, and in what ways are they different from me.
Parker also chooses a graham cracker, but the orange cat chooses differently from him.
Ew, yuck, I don't like graham crackers.
Now watch what happens as Parker sees the orange cat struggling to open a box. This yellow puppy is nice to the cat. The blue puppy is mean. Even after witnessing the blue puppy's bad behavior, Parker likes the mean one.
So it's almost that he wants to punish those who don't have the same opinion as him.
What we find over and over again is that babies will choose the individual who is actually mean to the one who has a different opinion from themselves. It seems that we're at a deep level built to not like individuals who are different from ourselves and to prefer those who are similar to us.
What is that telling you? Is that depressing?
I think it's, I think there's a lot of reasons why we might be built to orient towards others who are similar to us, to want to hang out with them and conglomerate with them. Yeah. You could think of it as, how the first special interest groups get formed, right?
In the same scenario, more than 80% of babies under a year old choose the mean guy. And with babies around Parker's age, a little over 1 year old, 100% of them prefer the mean guy.
So does this mean that bias is inherent, and that bias is sort of built into us?
I think it does mean, we're biased to others who share our opinions or are similar to us in key ways. And I guess to try to spin the positive is if we're built to dislike differences, we're built to like similarities. It's remembering that someone is like us in some way that gives us the connection to them.
We've seen babies express positive feelings, liking good behavior and rewarding good behavior. And we've seen them express not so positive feelings by discriminating against others. So what do these studies mean in the long term? Karen Wynn and her team at Yale hope that by studying these innate feelings of babies, we can all learn where our moral beliefs come from. Anderson Cooper, CNN, New Haven, Connecticut.
All right. Pretty thought-provoking, right? It starts in infancy. So what they talk about in the video, the implicit bias, is in our nature to be drawn to other people who are similar to us in key ways. And some of the other research I've seen, there's something from the American Values Survey from the Public Religion Research Institute, shows that 75% of whites, 65% of blacks, and 46% of Hispanics had homogeneous networks, completely composed of people who shared their own race. So what we tend to do is we build these echo chambers where it's hard for us to empathize with and understand the experiences of others who walk through life differently. In the video, they call it implicit bias, and sometimes we call it unconscious bias. So let's talk a little bit about exactly what that is. A bias is an inclination or a preference for something that influences our judgment in favor of or against it. And unconscious just means that it was developed without our conscious intent. It is implicit within us, so we can really use either one of those terms. But basically, it's a judgment about a group that we did not develop on purpose. And when you say that another way, the very nature of unconscious bias is that we don't know we have it. So I want to start by showing you how this works, right? So we're gonna have a little fun here today. We're gonna start with some math. I know everyone in here. We have anyone that loves math? Okay, we're gonna start with some math. And what I need you to do is, I want to see how quickly you can solve the problem that I'm going to give you on the next screen. So as soon as you think you know it, this is the audience participation part. I know we've all been sitting in silence, but I would love to hear you shout out the answer, okay, as soon as you figure this out. So it's a quick, easy story problem. So here we go. A bat and a ball together cost $1.10.
105.
Oh, already we have an answer. 10 cents was the first one I had, right? I heard somebody else say 105. Let's dive into that. Anybody else get 10 cents? Okay, 10 cents is the most common answer. It's actually the incorrect answer. 5 cents is the correct answer. And when you think about that, if the ball is 5 cents and the bat is $1.05, which is $1 more, together they equal $1.10, right? So what happened there? Why did some of us, I heard somebody say 5 cents, so somebody got it right. But why do we jump to the 10 cents? Even when you look at it now, it seems like, okay, my first quick answer might be 10 cents. I might be drawn to that. Well, the problem is that our brains can deliver these fast, really quick, instantaneous answers that can be incorrect. They can fail us sometimes. So let me show you another example. When you look at these two lines and I ask you which one is longer, you might originally say, well, it's pretty clear that line on the left is longer. And then you might say, well, maybe those curved lines or the angled lines at the end are making me, my brain is tricking me. Maybe this is some kind of an illusion. So you might have this kind of divided mindset. And what happens is, on one hand, you've got this gut feeling that says, well, that one line is longer. But then your analytical brain kicks in and you think, okay, my reasoning tells me this is just an illusion. This experience of having something appear to be true when you know it is false is actually a really good example of the two different systems at work in our brains. I'm going to talk with you a little bit about that. So there's a Nobel Prize-winning psychologist named Daniel Kahneman. He wrote a book called Thinking Fast and Slow. And in the book, he talks about these two cognitive processes for decision making, and he divides them into System 1 and System 2. System 1 is really fast. It's like an autopilot. It's instinctual, it's automatic. We use it all the time because it preserves our mental energy. It's very easy to use, but the disadvantage is it's very inaccurate. That's what happened with the ball and the bat problem. Right? Immediately we could jump to a quick answer, but we had to kind of stop and think about it before we understood, oh, maybe the answer isn't 10 cents. So that's where System 2 comes in. So System 2 is slower. It's attention intensive. It requires us to focus. It requires uninterrupted effort, a lot of times for us to sit and think something through. It can solve these complex problems and it's really reliable, but it takes a lot of effort and energy. So we might engage System 2 for things like parallel parking, comparing the pros and cons of an expensive purchase. And system 1 is more like, I'm going to recognize that person. Their face is someone I've seen before. I'm going to understand how to read these sight words. I know what 2 + 2 is, because we kind of learn these automatic and instantaneous things. Our brains don't have the capacity to function on system 2 all of the time. It would require way too much energy. We have way too much input coming in. And in fact, we need those mental shortcuts that system 1 gives us. But behavioral science shows us that people don't engage in as much slow and deliberate reasoning as they think they do. So in fact, we only use those system 2 brains about 5% of the time. About 95% of our brain activity is in that system 1. So what exactly are we doing with all of that unconscious brain power, right? So our brains at any one moment in time can be exposed to almost 11 million pieces of information coming at us, but we can only process about 40 things at once. So in order for us to really make sense of the world around us, we start to put things into patterns and into categories. So if you think of when you're a baby and you're crawling towards the outlet and someone's yelling at you, no, then you start to learn the difference between safe and dangerous. And you start to learn the outlet is dangerous for me. Over time as humans, this is a really important function for us because it keeps us alive. It helps us make sense of the world around us, right? In fact, in earlier years, it was probably really important for our ancestors to understand this kind of thing. And you can see how our brains have evolved to see something like a snake on a path where we don't get down and use our system 2 brain and analyze, like, what is this thing? And is it something that could harm me? Is that a poisonous version of snake? We just learn, I see a snake, I jump out of the way. Like, we don't even have to think about that. So this is a mental shortcut that our brain creates in order to help us respond rapidly to the world around us in these situations where we've had a similar experience before. Again, these mental shortcuts are a natural aspect of being human. This is how our brain works, and it's helped us survive, but it also has some detriments, right? Because what do you think happens when we apply this tendency to groups of people? What do you think we create? Stereotypes. Exactly what we create. So what is a stereotype? Well, it's an oversimplified, overgeneralized idea about a person, a place, or a thing. It's one of those mental shortcuts that helps us make sense of our social world, right? Because it reduces the amount of processing or energy that our brain has to do. Because when we see something that we've seen before, we can understand what it is. So we categorize objects and we categorize people. And it's all around us. It's things like that person is a bus driver, or that person is a Muslim, or that person is a Christian, or that person, we have all of these ways of making sense of the world that just automatically happen in our brains. But the dangerous thing about these stereotypes is that they make us ignore differences. So we assume that the same thing is true about every person who we might categorize within that group. And there are all kinds of stereotypes, right? On the screen you can see maybe one is all women are good cooks, or one is all men know how to fix things, or maybe it's everyone who's wearing a stethoscope around their neck and a white coat is a doctor, right? We start to kind of make sense of the world around us, and it's really helpful because they help us know what to do. Like when you walk into school and you walk into a classroom and you're a child and you see an adult in the room, you assume this person's the teacher and I'm going to follow what they say, we hope, and they're going to help me learn. So we know what to expect from the world around us. So if I asked you, in your mind, just picture that you're in an airplane and you see the pilot come out of the cockpit at the end of the flight and he's walking towards you. What does he look like? Now, I did use the word he, but I suppose most people would not assume that a pilot looks like the individual on the bottom half of this picture. right? You have kind of this image in your mind of what a pilot is. If you were looking at a lineup of people that you were going to hire for a pilot job, would you look at this person and think, this person in the bottom half, and say, you know, there's something about her, I just think that she would fit right in to our organization. I think she would be the best person for the job automatically. Well, if you have this idea in your mind of what a pilot looks like, even though that's not something that you may be consciously doing, you might still be doing that. And you know, for the people on the receiving end of this, like picture if you are her and you were applying for this pilot position, this is something that, you know, just creates a really hopeless, helpless experience for you as you've gone through life and been categorized and stereotyped over and over. It can really lead to this feeling of exasperation, that you're just constantly misunderstood, that you're being judged, that you know, you're being held back, and that other people are going to think this way about you no matter what you do. So circling back to the bias that I started talking about a few minutes ago, I just want to make a few important points before we move on. There's two types of biases. There's conscious bias, and then there's the unconscious bias, which is also sometimes known as implicit bias. And those unconscious biases are these social stereotypes that we form outside of our conscious awareness, and they're not limited to race or ethnicity. They can be around any social group. We all hold them, and they stem from this very natural human tendency to categorize things to make sense of the world around us. And the thing is that these unconscious biases are far more prevalent than conscious biases that people hold. And they're often, in fact, incompatible with our conscious values. And so we deny that we hold these unconscious biases because we want to believe that we're good people. And we are good people, right? We have strong morals and we have strong values and we want to do the right things. And we are all subject to unconscious bias, to this happening in our lives. So let's talk a little bit about how prevalent this is. We can see that it exists. We may be able to even kind of see it in ourselves and how our brains are working. But is there any way to measure how often it happens? Well, in fact, there is. There has been some incredible research done by Project Implicit. And this is a 401c3 that is a partnership between the University of Virginia, the University of Washington, and Harvard University. They created a test over 20 years ago that's now been used by millions of people in over 20 countries called the Implicit Association Test. And it works by measuring how quick you react to pictures as compared to words. More than 28 million IATs have now been completed. And I just want to show you some of the aggregate data that we have about the types of unconscious biases that people have. So the results of these tens of thousands of tests found 88% of white people who took the test had an anti-Black bias. 83% of heterosexuals had an anti-LGBTQ+ bias. And similar patterns and preferences were true for Christians over Jews, men's careers over women's careers, and the rich over the poor. So those are really some jarring numbers, right? Almost 90% of white people who took this test had an anti-Black bias. But what I thought was even more striking for me when I first saw this research is that the underrepresented minority groups internalize these same biases. So almost half of Black people, 48% of Black people who took this test had an anti-Black bias. 36% of the LGBTQ+ community had a bias against their own community, and 36% of Arab Muslims had an anti-Muslim bias. There's some new research that's coming out to collectively analyze all of the data that's been collected over these 28 million tests. What was really also interesting about this is that when you go out to take this test, they ask you if you consciously hold these biases, and the large majority of people say no. And so I just think this is really important for us to understand. I think it's not widely known or talked about, and this data is out there. So we can see it happening in ourselves by some of these exercises and activities that we've gone through today. We can also look to the research to point to the fact that it's really, really prevalent. And when we think about why it matters, this bias operates at a very kind of subtle level, right? So it's not always something that has these big, obvious effects. Sometimes it's that you might unintentionally say something that offends another person. Maybe you just feel a little less empathetic to people who aren't similar to you in key ways. Maybe it's that you forget to invite someone to be a part of something or to come to a meeting. Or maybe it's that you interrupt some people far more often than others. We talked about interruptions a little bit earlier today. And interruptions are one thing, but considering what we know about how unconscious bias really operates and how prevalent it is and how it's kind of below all of our awareness, what if it also determines, whether or not you will hire the most qualified candidate for a job, or whether you give an employee a fair performance review, or whether you hire the right CEO. So all of these processes within an organization, you can see how this invisible dynamic really dramatically affects almost everything that happens within an organization. So what should we do about this, right? Well, a vast body of research demonstrates the business case for diversity, equity, and inclusion work to be happening within organizations. And these are some stats. I'm not going to go through all of these today. I do have a link on my webpage that you can go and access this data if you'd like to look at it later. But essentially, to summarize, companies that are investing in DEI work have a competitive edge. They have better decision-making and unique thinking from this deeper, more comprehensive collective worldview from their diverse workforce. Inclusion has been shown to reduce turnover, to boost engagement, to boost productivity, to unlock innovative potential, and ultimately, as we've talked about a little bit earlier, it drives financial performance. So, these are some highlights within the research, and I agree, this is something that all companies need to be paying attention to. But as we circle back to the most important reason to be doing this work, it comes back to people, right? This is about the fact that when we don't intentionally work on diversity, equity, and inclusion in our organizations, whole groups of people can be judged, can be harmed, can be denied the opportunity to achieve their full potential. So we've done a lot of cognitive work today and really tapping into our intellect, but this work is about both the head and the heart. So I just want to have us stop and flip the switch for a moment and think, if we're not using the logical part of our mind, getting in touch with our feelings, think about, just reflect for a moment, what does it really feel like when you walk into any space and you feel like you belong there and you feel welcomed and respected and valued and heard and understood? And think about what that does for you. And think about what that would do if everyone felt that way. So when we remove these things that cause us to feel less than, then we start to become more than. We start to become more energized and more passionate and more open to change and more resilient. We start to find more purpose and fulfillment. And so it's good for us in a deeply meaningful way. And, oh, by the way, it's good for business, right? It's good for maximizing what our talent can do. And I guarantee that our customers are going to be much happier interacting with people who are feeling this, right? It's going to spread. This is the magic behind DEI. And this is really at the heart of why we do it. So I'm going to talk a little bit about, in our last segment here, about specifically what each of us can do to combat the effects of unconscious bias. So you have a handout on your table. It looks something like this. says growth at the top. And just so you can take some notes here if you'd like to. But I did capture a lot of language here so you can take it away with you and you can feel comfortable just sitting and listening as well. So we're going to start with this as we look at the growth model with the G. First, we need to get comfortable being uncomfortable, right? We have to understand that we only grow in spaces of discomfort. We have to push ourselves to a place where we're not comfortable anymore in order to experience growth. We also need to acknowledge that when we face uncomfortable truths and when we try new things and when we make mistakes, we feel discomfort. We feel strong emotions, and that's normal because that's a human response to trying something that's challenging. So we need to expect to feel these emotions as we start to engage in this work. We also need to understand that when we try new things and when we make mistakes, we can categorize those mistakes as good mistakes because those are things that teach us something. And as long as we're walking away having learned something, it's better that we made that mistake than if we never would have tried it in the first place. Second is recognize and interrupt bias. So first, we all just have to kind of reject this illusion that good people are not biased. And we have to instead focus on becoming a better person. I encourage you to really go out. This implicit association test is free to take. There's some information about it on the back of your handout. And you can take it on a number of different identities when you go out to the site. I recommend actually doing it from your mobile device. It's a little bit easier than doing it on the computer. It's very quick and easy to take, and it really gives you a good idea of the biases that you hold. So when you find out that you have these unconscious biases, because we all have them, I encourage you to just sit with those results and not immediately discount them and think about how they could be impacting you in your life. And just start really paying attention as you move through your day. Right? I think especially pay attention to any kind of gut feelings you have or any assumptions that you notice that you're making about people. Those are all clues that it's unconscious bias at work. So that's really about engaging your system 2 brain, slowing down your thinking and being analytical. But we know that so much of our brain processes things unconsciously that we also need to account for that. So don't just rely on your willpower, right? There are ways to kind of hack an inclusive autopilot and kick it into gear. The first thing that you need to do is kind of build these systems and routines in. I think Megan talked about if it's on your calendar, it will get done, right? So something like I'm going to schedule a lunch on my calendar once a week in a new part of town that I haven't been to or a restaurant I haven't tried. Or I'm gonna invite someone who I don't know at my organization to have a coffee with me as part of a mentoring conversation, and I'm gonna ask them to share with me some things about their personal life. We need to start scheduling these things in. Then you can really look at your work processes. Now today we're really talking a little bit more about individually what we can do, but there's a whole host of things that you can do in your organizations as well. And when you look at the work processes that you personally use every day, this is where structured standards really make a difference. So anywhere that there is kind of objectivity in how you make decisions, you need to replace that with some consistent criteria and some transparency about how those decisions are made. So for instance, if you're hiring talent or promoting talent, spend some time clarifying exactly what is the performance criteria required and communicate that to the candidates in advance so that everyone is clear on it, and compare those candidates in an equitable way across those different interviews that you're having against the criteria that you've already established, right? You can do this in almost any process. Bias really seeps its way into the processes in our organizations. So you can evaluate, things like how you're recruiting, how you're interviewing, your job or promotion criteria, your goals for performance or development, how you run your staff meetings, how you have your one-on-ones. There are ways that you can really build in ways to kind of outsmart yourself. Widen your lens. So take responsibility to teach yourself what you don't know. Mind who you follow on social media and where you get your news and where you get your entertainment. So one thing I like to ask people is an easy test, look at your LinkedIn feed. How much diversity is in your LinkedIn feed and who you follow? And what kind of diversity of thought is there? You know, are most people kind of promoting the same ideas, or are you exposed to a lot of new and different ideas? We tend to seek out information that validates the opinions that we already have, right? If you've heard of confirmation bias. Psychologist Anthony Greenwald says, we like to think that our mind is like an impartial judge in search of the truth, but it's more like an attorney searching for evidence to support her case. Anytime all of the information that we get confirms the point of view that we already have, that's a sign that confirmation bias is in place. We can combat that by seeking out, books and movies and podcasts and every opportunity we have for input from others who are different than us, sources outside the mainstream. So really seek out those diverse perspectives. Try mixing it up. So anytime you have kind of these familiar patterns, like we give all the best assignments to this person on the team, or this person on the team always takes the notes, this person always cleans up after the events. Really make an effort to rotate responsibilities, right? Facilitate meetings in ways that are very purposeful, that draw input from everyone instead of just allowing whoever speaks up or whoever has the loudest voice to kind of have the most airtime. If you have a big decision to make, get input from people who are beyond your go-to people, right? So just kind of constantly try to expand and add new perspective wherever you can. And this is a really big one. When you're hiring, the term good fit has long kind of been a coded term for most like us, right? So whenever you have kind of this gut feel that somebody what might be a good fit, that's kind of a red flag that unconscious bias might be at play there. So this is where those objective criteria that you set up come into play. And this is also, when you are thinking about bringing someone in and the reasons why you would bring someone in, I encourage you to start thinking about culture add instead of culture fit. Like, in what ways could we bring in talent that's really going to help us expand and grow? The last piece is help, mentor, and sponsor. So notice in any situation who is not in the room or who is not participating and invite them in. When there's dominant views that are taking over, just really acknowledge what you can do to amplify the unheard voices in the room. For instance, if your female team members in the room are being talked over, we've talked a little bit about interruptions, it's really easy to direct the conversation back to them. To say, hey, I think that Rita had something really important to say, so let's just go back to her for a moment. It's a really easy way to support and amplify someone's voice who might not be heard. Let's talk for just a moment here at the end about mentoring and sponsoring. We've talked a little bit about that, but I really want to clarify these are two different things. The main difference is that mentoring is really about someone providing you with advice and feedback. And sponsoring involves someone directly advocating for you on your behalf because they believe in your ability and potential. They're saying your name when you're not in the room. And we do need both. We need both to succeed. But we're often tempted to mentor and sponsor people who are a lot like us, right? Like, we can give them advice, we think, because we've been there and we can see how our path was and we can see how their path might be similar. But what could mentors gain from building a relationship with someone who could help them expand their own understanding of the world and their own cultural competence, their relevance as a leader invested in diversity, equity, and inclusion? A really important point when diverse talent enters an organization too is to seek them out intentionally and share inside information about working there. So all those unspoken rules that people need to understand in order to function effectively, those are really hard to pick up on. And as you share those with people, you can really build a relationship that will allow you to, in the future, mentor and sponsor them. So the thing is, there is just so much that we can do here, but we have to do more than just believe that this is important. All of us have to take some action, to do something. Every action that we take individually adds up. Everything that we each do creates some collective momentum and helps us to move the needle. So as I close out today, I just want to invite you to take a moment and process what you learned. Because I know I shared a lot with you. We've heard a lot from the other speakers that have been, really incredible insights. And I just want us to take a moment and reflect on how this applies to each one of us. This is a really important part of the learning process, so I'm just going to take a couple minutes here and lead you through a little reflection. So I'm going to invite everybody to kind of just settle in, take a deep breath, and just find a place to focus on with your eyes, or if you feel comfortable, you can even close your eyes. Just let your mind shift gears and drift inward. And I'm going to ask you a few questions just to help you follow your thoughts and process everything that you've heard today. So first, how are you feeling right now? What words would you use to describe your emotions? Are you feeling one emotion strongly, or perhaps a mixture of things? Whatever you're feeling, acknowledge it as a response to this new information that you have. Now take a step back and reflect on everything you heard during our time together. What is top of mind for you? Did something really resonate with you? Did something surprise you? Did something deepen your understanding? Or is there something you want to understand better or explore further? Take a mental note of the key ideas and the questions that are arising for you. Now consider, how relevant is what you learned today? How does it fit into your understanding and align with your values? Consider whether it equips or empowers you in new ways. How is what you learned today important for you personally? In what ways is it important for your organization or your community? Is it important to do something with this information? If you do nothing, what might happen? What exactly do you want to do differently? You have a unique position, you have influential power, and you can use it to make a difference. So what will you do? How will you be different after you leave? In another minute, I'm going to ask you to open your eyes, and on the back of your handout, there's a space for you to write down any actions you will take when you leave today. So I'm going to ask you to identify some ways to activate and apply what you've learned. So just give yourself some time to consider what you will choose to do, what you will commit to, and what you will write down. And when you're ready, open your eyes and use the space on your handout to write your thoughts and commitments. And I'll give you just a minute to do that. Give you about 30 more seconds, so jot down any last thoughts you have, and of course you can continue to think about this when you leave. All right, we are running right up on time here, so I'm going to pull us back together. I wanted to take just a moment, though, to ask if anyone would be willing to share one commitment that you made. Is there a brave soul in here who would be willing to say, here's something that I'm going to do differently when I leave? Yes, in the back.
I just wrote down, I will not do nothing.
I love it. We can't do nothing, right? There's so much that we can do. I know it's been probably an overwhelming amount of information today. We all just have to choose to do something. I'm going to leave you. One of the things I didn't share at the beginning is that I am a huge Star Trek fan. The original series is my favorite. I really love all of the examples of diversity, equity, and inclusion in the show too. And I love this quote from Spock. I think my sincere hope really is that today you have all been equipped with some new knowledge and that you can join me on my quest for, continued growth and development. And I would love to talk further with you. I know we're out of time today. I will be around for a few minutes after we leave here today. And I just really, again, want to thank all of you for your attention right up until the end of the day. It's been a lot of hours of sitting here. There's been some incredible insights shared, and I've really been pleased and honored to be a part of it. So thank you, everyone, for your time.